Do we have any questions from anybody? I guess we only have one person watching, so probably the answer is no. This is an unannounced live stream. I'm just kind of trying it out. The people said that you can do now question and answer live streams, which I want to see what that looks like, because I kind of decided not to do live streams because I didn't think they would be good for question and answer, but I guess YouTube rolled out a feature for that now, so I should check it out. Oh, somebody liked the live stream. Thank you. Ooh, we're starting to get people now. We got 4 people. So for the people who just joined, we're trying this new feature on Google, which is the live stream question and answer. I recently did a video saying I was going to do live streams because I didn't think they'd be good for question and answer. And then I, like 2 days later, YouTube sent me an email being like, hey, we have this new live stream question and answer thing. Why don't you try it out? So, I mean, they didn't send it to just me. It was like a mass thing they sent out, but want to give it a try. So people have questions. People are always asking, how do I make sure my question actually gets answered? This would be a good means of doing that, I think. Ooh. All right. We have our first question from you, Nancy. How can I negotiate an exit package? So the question, I'm gonna answer your question with a question. Do you have leverage? Do you have claims? Have you been sexually harassed? Have you faced discrimination? Are there unpaid wages that you're owed? And are they trying to get rid of you? Do they want you out, or you just want out? So Nancy, if you can throw that in the chat down below, I will go through piece by piece and try to give you the best I can of how
we were family, I would tell you at the dinner table, this is how you should negotiate a package. Don't leave me hanging, Nancy. I need details. I'm just kidding. I know it takes time to type. So Nancy's, I suspect, typing. I'll say this. In the absence of any kind of leverage, so I call a claim a leverage, right? Like that's a source of leverage for you. That's something you can use to scare the employer, to threaten the employer. In the absence of leverage, really, when you're trying to get an exit package, you're saying please, right? And if the employer doesn't want you to go, they're probably going to say no, because why would they incentivize you to go, right? If they do want you to exit, it's 50-50. If you're leaving with no leverage whatsoever, they might give you a package because they just don't want the chance that you might sue them. Any package you receive is generally going to have a release of all claims. So that is fundamentally why they give a package. They're getting you to sign potentially mutual non-disparagement, potentially confidentiality, depending on whatever jurisdiction you're in. That's not legal in some jurisdictions. And they're also generally going to be getting you to sign a release of all potential claims. So they're paying you to be sure they're not going to have to litigate with you, right? And they'll do that even if you don't have claims, because fighting off a case can be rather expensive, even if it's not legitimate. And I'm not saying, I don't know if you have a case or not. I'm certainly not saying it is or is not legitimate. I'm just saying the cost of them fighting with you is often more than the cost of what a package would be. So I'll pause there because Nancy gave us some further details. She went on. So Nancy's first question was, how can I negotiate an exit package? And I asked some details, and she responded, recently placed on a baseless performance improvement plan. I then raised a harassment, bullying, and discrimination grievance. They are still investigating. I made it clear I don't want to stay in a place that I'm unappreciated. All right, Nancy. So you do have leverage. You complain of discrimination. That two things. One, it is a claim in and of itself. Your discrimination claim is potentially viable and valuable as a lawsuit under federal law, and it may additionally be viable under state and local law where you are. So you have a source of leverage. You also have a secondary source of leverage because now that you've complained, you've locked in protection against retaliation. And what that means for the employers, if any one of their employees, any of them, does something nasty to you, something that amounts to a workplace, a negative work consequence, that's going to hand you a secondary claim called a retaliation claim that can be won or lost separately from your discrimination claim, right? So you have two sources of leverage, and that retaliation claim, it's got a burden shifting component to it where the employer actually carries the burden of evidence, right? The easy shorthand for that is that you've heard the phrase, I'm sure, innocent until proven guilty in the US legal system. For lack of a way to explain it, the employer will not be innocent until proven guilty of retaliation, where there is a negative workplace consequence that takes place right after you've complained of discrimination. Instead, you can think of them as guilty until proven innocent. And that burden shifting is a big deal for you. It makes your case potentially easier to win, and so is a source of even more leverage for you. So we've established you have leverage, Nancy. And what I'd probably recommend to you is one of two paths. You seem on top of this. So you are one of the few people in the world who I say, hey, maybe you don't need an attorney. Maybe you don't. And if that's how you feel about it, I would probably urge you to go to them and say, hey, listen, I've got this discrimination claim. You're worried about a retaliation claim that could crop up at any moment because things are getting tense over here in the workplace. And I've been speaking to local employment attorneys, and they tell me I have a claim and I can sue you under federal and potentially state and local law. But I don't want to do that. I don't want to do that. I'm Nancy, and I'm better than all this, and I want out. I don't want to sue you. Why don't we have a conversation about what it's going to take for you to do right by me so I don't have to sue you? That's a very realistic conversation to have. And an intelligent employer, represented by an intelligent defense attorney, would probably say, well, Nancy, what do you want? And then you're having a conversation about what you want. That's a pretty good conversation to be having. I can't guarantee they're going to give you what you actually want. They might not meet your number. But if you can have that conversation, at least you're on the right footing. At least you're heading in the right direction. The second thing I would probably say to you is 99.9% of people in your situation, I'm going to tell to hire an attorney. Instantly, people are going to be like, oh, Vince, you say that because you want people to hire you. No, I don't know where you are, Nancy, and you probably can't hire me, and I probably wouldn't take your case anyways. Not because it's not a great case, just because I think you should find local counsel, because local counsel doesn't have to fly attorneys around the country. So local counsel is going to be cheaper than my firm. So I can assure you, I'm not telling you to hire an attorney because I want you to hire me. I'm telling you to hire an attorney because I think an attorney who actually does this for a living will potentially reduce risk and add value to your case. So if you're in a situation where you don't feel up, to kind of engaging in that plan that I got for you there about, listen, I don't want to sue you, but if you want to pay me to exit, we can talk about that. If you don't feel up to that, or if you don't feel comfortable, or if you just don't want to do it, then I would probably recommend hiring an attorney because you do have leverage. It sounds like, and I don't know the details of your claim, but you're telling me you have a discrimination claim and you're telling me you complained about it, right? Hopefully you complained in writing, right? Hopefully you have evidence of when and how you complained. That's really valuable. If you don't, want to get it in writing and keep a copy of it. Just a heads up. And the next thing you ought to be doing, and I know it's a holiday weekend, but schedule some free consultations with local employment attorneys. Have some conversations about if they would take your case and just be clear with them. Like, listen, I complained. They're worried about retaliation. Here's the discrimination that went on, and I want out. And here's what I want. And those attorneys hopefully will be frank with you and say, hey, I think that's very reasonable. Or, Nancy, I don't think I can do that for you. Oh, amazing, Nancy. You did it in writing. You know what you're doing. I don't think you may not need an attorney. You may not. You may want one, and you might do a little bit better if you have one, but and this is a very short interaction, but I feel like maybe you don't need it because you're asking all the right questions. And your expectations in terms of being done with them, it seems like you've researched. Seems like you know what you're doing. So I'm going to keep talking about if you hire an attorney just because it's useful for other people. But a lot of times when people come to me like, I don't know if I should hire an attorney, 99% of the time I'm going to say, you should definitely hire an attorney. With you here, maybe not. Maybe you don't need it. That's my thought on that. Now, the problem with hiring an attorney is you pay the attorney. You pay them some percentage, hopefully, of whatever they win for you, right? So you have to hope that they're going to win you enough to be worth that percentage, right? If the company was offering you 10 grand and the attorney only gets you 2 grand more and then takes a third or 40% or whatever their percentage is, did you end up better off? I don't know. Got to count the money in your pocket. Is it actually better? On the other side of that coin, you didn't have to do the work. Somebody did a lot of the conflict for you. And a lot of people tell me it feels really good to have a team fighting for you in these situations because it's you versus the company to some extent, right? And that can be daunting. I don't know anything about your company, but often people tell me it feels like hundreds or thousands of people against one, and that does not feel good. So having people who are fighting for you can be really nice and feel vindicating and cause you to feel empowered. I've heard that from a lot of people, although I don't know if that's a good enough reason to necessarily hire an attorney who's going to take a big cut if you don't need to. I think that's more of a personal question. What else can I tell you, Nancy? Is there anything else that I can clarify? Is this useful to you? Have I been responsive or helpful in some way? I think we're also on a bit of a delay here. So when I say things, I think a lot of time passes before Nancy sees them, which is why we're slowly communicating, but we're getting there. Live is a strange medium for communication. Oh, I'm really glad to hear that, Nancy. If you have any follow-up questions, I have to think of them right now. If you have follow-up questions, if you ever want to just post them below this video or really any video, I check all the comments. I'll try to make you follow-up answers. I know at least how I research is I'll like take in a bunch of information and then I'll think about it often overnight or like over the weekend or whatever. And then at some point I'll have just a list of additional questions. I don't know if you engage in the same process, but that is how I do it. And I would just want to make those additional questions, we can answer those. Like there's no reason not to. Okay. Good luck to you. I hope you get paid and I hope you get out of that place and you're done with them forever. And I hope you get mutual non-disparagement and that they protect your identity and all the good things very much. I'm just sorry you have to deal with the situation. It's never a good time if you're speaking to an employment attorney. I've never seen someone who's like, I'm here to speak to an employment attorney because everything's great. The only people who are ever in that situation are like executives who are negotiating custom compensation packages because they've now gotten a promotion to so high a level that they don't have like normal rank and file packages anymore. Everything's a negotiation. Those are the only people who are ever like real excited to see me, right? It's nice to feel like you're helping people, but you're well aware that no one's ever happy to see you, right? All right. If I don't get another question in the next 2 minutes, I am going to end the live stream. Not because I don't want to answer further questions, but just because I don't want a lot of dead air on the live stream. So 2 minutes from now, we'll do it. Can you all see all my wonderful snow in my backyard? I love rural New Hampshire in the winter. It is a delight. It gets dark here about 4:30. I guess that's everywhere to some extent. It's, close to the darkest day of the year. The shortest day of the year, I guess, the shortest daylight span. Anyone have really exciting New Year's Eve plans? As I try to make small talk on gonna be doing it up. Oh, Nancy has another question. If I want to resign out of the company, can they let me go as the case is going on? So my recommendation is if you are going to be hiring an attorney and suing them, or even just suing them on your own, if you can, try to stay. It will potentially give you additional leverage because the whole time your case is pending, they'll be afraid someone in the company might retaliate against you and give you additional claims. Now, the other side of that is your well-being. Quality of life, going to work every day at a company that you're suing can be horrible. And a lot of people find it very stressful and unpleasant and don't want to do it. And I always tell people there's never going to be an employment case that's valuable enough to be miserable over. So in terms of whether you should stay or go, it is a personal question. My staunch advice is if you're purely looking to maximize the value of your claims, I would stay. I would. But that's not the only consideration. Now, you're also, I think, can they terminate you if you're bringing the case? Oh, I'm sorry, but Nancy clarified that her well-being is highly affected. So 2 things, Nancy. 1, put your well-being first. Always. Your case is going to have a value even if you leave. I don't know what that value is, but I assume you've been wronged based on what you're telling me. And if you leave now and you just say, listen, I can't go on here. Things are too bad. I can't stay. Argument your attorney can potentially make, right? Later on, your attorney can say, listen, there was no way you could expect her to stay here, right? Now, I think you're also asking, can they fire you if you're bringing a case against them? And I've said this on the channel a couple of times. Technically, that would be retaliation, right? If they terminate you shortly after you complain of discrimination, that is retaliation, and it could be a sizable retaliation claim, right? It would be illegal to terminate against you. The problem with that is that murder is illegal too, but sometimes people do it. And retaliation is legal, not in a criminal sense, but in a civil sense. So, it's kind of an age-old joke amongst lawyers. Anything that has a fine attached to it or just a civil code, right? If you can only sue for money over something, then attorneys will often say, well, it's legal for a price. And there are companies, discrimination, are generally going to enjoy significant workplace protections and be at that job for as long as they choose, really, unless they do something really horrible, right? Um, but I can't give you definites. And also, you should be checking with local counsel because the laws where you are could have additional protections. Certain states have additional protections, and I'm only speaking to the federal laws here. I don't know where you're located. And if you're located outside of New York State, I'm not even allowed to answer your questions except as to the laws that pen through the EEOC, as I kind of mentioned in the description for the live stream. So all of this, all the answers I'm giving you are just under the federal law. And you would want to speak to local counsel to, one, check everything I've said, because you never know. There could be strange things going on in your state. Two, you might have additional under state and local law that can make your case even more powerful. And you should know about that. Because if you go in just knowing about your federal leverage, I mean, you might not be fully armed, right? Let's see. Okay, Nancy asked to follow up again. Would they keep the person that I have raised the grievance against? Will the person carry on working for the organization despite the grievance? All right. I am not a teller. Generally speaking, I see it go about 50-50. About half the companies that we go after, if we do a good job of substantiating and proving what that person did, what the bad actor did to you, then I would say about half the time that person gets fired right away. The other half of the time, they don't get fired right away because the company needs them as a witness during the litigation. So oftentimes what you'll see, and I'll explain why. Let me pause here and explain why they need them. So often in 2022, a lot of these cases are he said, she said. And I'm just using pronouns there. It could be he said, she said, or any set of pronouns anyone wishes to use. But it's a one-on-one altercation, often in 2022, because people have learned what they can't do in crowded rooms, right? In the 80s, a lot of the cases in our field were people walking into crowded rooms, dropping racial slurs, or people engaging in wild sexual harassment in crowded cafeterias and things of that nature. And it's not that people have gotten better. They're not better human beings, but they are more clever. There's a bit of an arms race. They're learning, right? So the crowded room became the email in the 90s. And then it became the interoffice instant message or text message in the aughts. And then in the 2000 teens, we see a lot of elevator talk. A lot of one-on-one in closed spaces where the bad actor feels there's probably no cameras or things of that nature. So I don't know what you experienced, and I don't know the situation, the setting that you experienced it in, but there's a decent chance that they might feel they need the bad actor as a witness in your case to counteract what you're saying. Because if they get rid of the bad actor, they may not be able to produce that person as a witness later, which means come trial, it's your testimony unopposed. There's no other witness who was present. That is a very place to be in for the employer. So sometimes what you'll see is they actually wait until after the case is settled or goes to trial before they kick out the bad actor. That often happens. And that is routinely a source of great angst to plaintiffs in our field because a lot of people really buck that claim that people just sue for money, right? In our field, that is generally not the case. People are suing because it's principle. They want other people to be treated the way they were treated, right? And part of that, as you're kind of highlighting here, it's very clearly very important to you as well. You don't want this person to be there. You don't want this person to go on and have the capability to do this again, right? And that's amazing. That's so noble of you. But there's a decent chance you're going to be frustrated because the employer's defense attorney might say, hey, you got to keep that guy. I don't know if he's a guy or not. I don't know who did what to you. I'm just assuming for sake of conversation, we're just gonna call it a guy. And the defense attorney might say, hey, you got to keep that guy. Got to keep that guy because we need him to testify. So one, employer, let that guy's supervisors know that they should paper his file so we can get rid of him later. It's very common, right? You kind of mentioned they put you on a baseless performance improvement plan, right? They're probably going to be putting that person who did this to you on a performance improvement as well, because they want it really documented when they want to get him out the door, right? So they're going to put him on thin ice, keep him, potentially use his testimony to try to fight the case with you if it goes that far. And based on what you're telling me, I don't know that it necessarily would, because it sounds like you want a settlement, and I assume they may as well. But once the case is all over and you have had to actually cut a deal or not cut a deal, go to trial, depending on what you choose, that then maybe when they get rid of this guy. And it may be very simple. Hey, you're an idiot. You cost us a lot of money. You had us go to this litigation because you're so dumb, bad actor. You do dumb things, and you're a bad person who does bad things. You got to go. We just kept you for the case. But that's so frustrating for people in your position, because often I'll have clients who are like being offered hundreds of thousands of dollars, right? And they'll say something like, listen, you can keep one of those 6-figure checks if you get rid of the person who did this to me, because I don't want them to hurt other people. And the employer will often say, not going to happen, when secretly the employer is absolutely planning to terminate this person later, after the case, after they no longer need them. It's a weird situation, and there's lots of strange motivations for the employer, and they're getting strange advice from their defense counsel. And it's good advice from the defense counsel. They do potentially need that witness to oppose you, because they need somebody to come in and say, hey, the things Nancy's saying didn't happen. And Nancy, I know they did, but they need someone who's going to testify under oath that they didn't. Because if they don't have that, it's your word unopposed. And it's a bad place to litigate from. All right. We're going on almost half an hour here. I will check the comments on this video, especially you, Nancy. If you have follow-up questions, if there's something else I can do to help you, we have videos on the channel about finding a good local employment attorney. If you want a link to that, let me know. I will get you that link. It might be worth it to you just to speak to 3 to 5 local employment attorneys. Get a feel for your local laws. Get a feel for your options in terms of hiring counsel. I'm sorry you have to deal with this. I know I said that already, but I'm just sorry. I'm sorry. Good luck. All right. Take care, everyone, and have a happy, safe holiday.